Good afternoon. My name is Renee Castillo de la Cruz, and I'm a staff attorney at the Texas Children's Commission. On behalf of the Children's Commission, I would like to welcome you to today's webinar entitled Non-Party Participation in Child Welfare Mediations. This presentation is provided by attorney mediators Mark Briggs and Electra Watson. Mark has been practicing child welfare law since 1998 and mediating child welfare cases since 2004. He's board certified in child welfare law by the Texas Board of Legal Specialization, and he practices in Far West Texas and mediates throughout the state of Texas via Zoom. Electra Watson is based out of Dallas, Texas, where she practices and mediates family and child welfare law. A PDF copy of the PowerPoint for today's presentation will be made available for download on the Children's Commission On Demand and Training MCLE webpage. For those watching the live presentation, a Q&A feature is available during this webinar, and questions will be addressed at the end of the presentation if time allows. For those watching this live, the MCLE course number will also be provided at the end of today's presentation. If you're watching the webinar replay, you may email cctraining@txcourts.gov for MCLE self-reporting information. It is now my pleasure to turn things over to our co-presenters, Electra and Mark.
Thank you, Renee. Good morning or good afternoon, depending on where you are. Today we're going to talk about who are non-parties, and Electra and I are going to sort of do this as a panelist fashion. We're going to take turns talking about it. So I think I'll go first, but I think Electra, would you like to talk about who non-parties are?
Well, primarily in the context in which we see them in mediations, it's anybody that's not directly involved in the lawsuit. As it pertains to child welfare, examples of that would be family relatives, and like licensing agencies and things of that nature. Um, so I mean, I basically I try and limit the amount of non-parties that are involved in the mediation, but obviously they occur. In Dallas, we try to incorporate non-parties in the process by way of an FGC, a family group conference, which is kind of a more informal thing, an exchange of information to get everybody on the same page. So we do have that mechanism in order to exchange information and to have everybody able to have the same information without really needing to involve a whole lot of non-parties in the actual mediation process itself.
Okay. Well, one of the things that's sort of unique about CPS mediations or child welfare mediations is the fact that we start out with a non-party. We have the child, who is the subject of the suit. And I know the child's status as a party or a pseudo party or a non-party is very much a subject that two lawyers can argue about for hours if they wish. But the child is certainly one of those people. The parties are going to make the agreement that eventually affects the child, certainly. But that's the whole point of it. And it has been my experience in the past that only very rarely do the children participate in CPS mediations. They may have their attorney ad litem present, perhaps the guardian ad litem is present too. In fact, that's very likely, as both of those people are going to be there by court order, but the child themselves rarely participate. I have seen situations where an older child, a teenager, a 16, 17-year-old child, has expressed an interest and arrangements are made to have the child there present. But that is very, very, very much something that happens only very rarely. At least it has been in the past. Is that your experience also, Electra?
Yes, and all the time that I've been doing this, I've only had a child participate twice, and they were, like 17 on the verge of becoming 18. It
Okay.
was one of those types of situations where they were about to emancipate.
Well, and what I will say in this area is that with some of the changes that have been made to the laws recently, and I would point everybody to the changes in how the permanency hearings are held and the requirement that the court visit with the children, it may be that we have an increased presence of the children at the mediation. So, certainly they're the ones who are going to bear the brunt or the result, I suppose, the consequences of whatever is mediated. But uh, I think that the children should probably be more involved than they are. I know it's always an issue. Well, you're having the mediation during school time. And so you have to balance the question of, is this child better off at school, or is this child better off in participating in the mediation? Uh, it's it becomes problematic, and we're going to talk about that later, when the mediation takes off in a different direction from what the parties expected, and that happens. And so the instructions that the attorney ad litem received from the child about the mediation may not have encompassed where you went. And so sometimes the attorney ad litem for the child is going to have to contact his client, contact the child, and find out, hey, this is what we're talking about now. How do you feel about that? And get that information. But certainly, I can see some advantages, and I anticipate increased presence of children in the future at mediation. Um, Electra, would you like to talk about placements, or would you like me to go first?
I'll go. I think that the placement is probably, if you're going to have a non-party in a child welfare mediation, that is the non-party that is most likely to appear. Typically, especially the closer we are to finalizing the case, and especially if the recommendation is going to be a continued placement with that relative or fictive kin, they are likely to be involved in the process because even though they're not a party, a lot of the things that we're finalizing in the MSA, such as possession, access for the parents, and things like that, really heavily involve that relative, and needing their schedules and availability or whatever is integral to that process. Also, in having a good understanding as to the relationship of that relative or fictive kin with both parents, or I guess I should say, the status of that relationship, whether or not they do get along well, whether or not that person does not want them at their house, whether or not, that person is comfortable being a supervisor, and so on and so forth. So I would say that in my experience, the relative and fictive kin are um, the most integral non-parties that I have had participate in the mediation.
In my experience is the same. Um, it, as a rule of thumb, and we're going to talk about more about this later on, is if somebody is going to take an active role, become a conservator, or provide some kind of supervision or something like that, and sometimes the foster parents agree to do something like that. If basically the sort of the rule of thumb is, if they're mentioned in the MSA somewhere, that person is a non-party who should probably be participating in the mediation process, because you want them to know what's going on. And that brings me to the next topic, is spouse of a parent. I'm going to expand on this a little bit. I'm going to include another one, a spouse of a party, I guess would be proper way, but I'm also going to include the parent of a party. We have situations where you have a minor who is the parent of the child who is the subject of the suit. And oftentimes they find themselves still in the home with their own parent. And sometimes that parent is somebody who is there present in the mediation. And we're gonna talk about that. And it's the same thing for a spouse. A spouse of a parent may not necessarily be a party to the CPS case, but they're nonetheless. And they are going to be kind of in the ear of the parent who is a party. And so that is something that the mediator and the other attorneys need to be aware of, that there's a dynamic in that room where there is more than one person who is involved in the decision-making process, or at least in the discussion of the issues that are being presented.
I mean, for us, and at least the way I conduct the mediations is, since we do it primarily by Zoom now, everybody is in their own breakout room. Typically, if they are aligned, I will put the guardian, CASA, and the department in the same breakout room, and then everybody else has their own separate breakout rooms. Um, Backing up just a step, as it pertains to foster parents, if I have foster parents on a call, again, if they have intervened, then they are a party at that point. So we're not talking about them in that context. But if they showed up just as a non-intervening party, I have them make sure that their names are not accessible or presented on the screen. So it'll just say foster mom or foster dad or whatever the case may be. The context in which I typically have foster parents in a mediation is typically if it looks like the outcome is going to be termination, and we're kind of looking at a conversation regarding some post-termination access. And even though I understand that that would be a different cause of action and the foster parents are not bound by, post-adoption, anything in the MSA post-adoption, it's good to have that conversation, at least something in writing, even if it's nothing more than basically a Rule 11 as it pertains to them about what their agreements were with the parents. My position regarding spouses or parents of non-minors parties, I try and limit that as much as possible. This far in the case, um, I mean, I have an expectation that it should be between the two people that are needing to co-parent, unless that spouse has something just imperative that would go to the substance of what we're dealing with in that mediation. I request that all spouses not participate. They definitely don't get a place on the screen. Now they might be in the room or something with the other person. I can't control that. But the purpose of this is to facilitate an agreement between the parties. So there's only so many opinions that I can take into account in order to move towards a resolution.
Sure, sure. And I handle that much the same way. I'm always struck by the idea of the party may deny that anybody else is there, and yet I see a shadow on the wall behind them. You've been there, I've been there. I'm sure all of the mediators listening have been there. The parties, if you're a party and an attorney for a party, you need to be aware that that does happen. That may be happening. In fact, it may have happened before, but be aware that that's out there. But the mediators themselves have limited ability to control that. Typically, what I'll do is I'll remind them to remember that the decision is ultimately theirs, and we'll talk about that a little bit more. Let's talk about some of the potential witnesses or people who are potential witnesses, but who may have information that is germane to the subject of the mediation. In this context, what I'm typically facing is a therapist for the child who indicates, the child is ready or not ready for a potential placement, that sort of thing. And that information needs to be conveyed. And mediation, I think, is an appropriate time to have that, because I think a parent who has an expectation the child is going to return home may want to hear it from the therapists themselves by moving into the breakout room. As you say, we do most of these by Zoom. Move the therapist in the breakout room and hear it from the therapist's own mouth that, the child may not necessarily be ready to come back home yet, but then also hear the information from the therapist that that's something they're working on. So that's the context I usually see it in. All of these things, the law enforcement, if you're doing a mediation early in the case, generally we're going to be talking about a mediation at the end of the case where we're taking care of things, wrapping it up for final. But mediations earlier in the case may have a law enforcement presence, and they can provide direct information to the parties about what it is that they saw or what they did, something like that. Teachers, neighbors, and other family members all can provide information to that. Is that what you think also, Electra?
Well, I will say because primarily, I mean, I practice primarily in Dallas County, and we don't have potential witnesses during the mediations. If there is information that needs to be provided from those people, it is generally coming from either the caseworker or the guardian ad litem. So the guardian ad litem will say, "Hey, I reviewed the therapy notes, and I am, the therapist is not recommending this, or the pediatrician is not recommending this." So we don't actually have the witnesses present during the mediation. And like I said, if those types of conversations need to be had, it's generally done through the FGC, which is a little more of an informal conversation. But I've never been a part of a mediation where we've had witnesses there.
Okay. Yeah, it is rare. It's very rare, but it's sometimes it's fact specific that requires that sort of presence. But it's not unheard of, I guess would be the best way to do it. Let's talk about the tribe next. I am lucky out here in far west Texas. We have our own tribe. We have a tribe here in town. We have another tribe just across the state line in New Mexico, and we deal frequently with the Navajo tribe as well, that's farther up in northern New Mexico and northeastern Arizona. So we do run across ICWA cases, and this is sort of a semantic discussion. The tribe always participates, but whether or not the tribe participates as a party is another matter. The fact is as a pragmatic matter, the tribe is there, they're going to have input, and if the tribe doesn't like what you're doing, they're going to just, some tribes, all tribes have the ability to just go in and say, you know what, we're not doing this, please give us the kid. And so you need to be aware, if you have a case with an ICWA component, don't even start that mediation until the tribal representative is there. Because the tribe, although they are not technically a party, I think, unless they choose to be. Sometimes they do. Sometimes they have an attorney represent them, and sometimes they intervene. It depends on the tribe. Even if they're there informally in sort of a supervisory position more than anything else, you need to have their presence at that mediation. Electra?
I think maybe it occurs a little less frequent here. Typically, whenever tribal participation occurs, in my experience, is usually at the beginning of the case, around the 14-day hearing, or when the department is made TMC. However, I mean, I feel like in our practice, they're treated pretty much like the Attorney General's office, which is we recognize they're a party, they don't really participate in anything, but before anything gets finalized or something, you kind of run it past them
Right.
to make sure that they're on board. So that's been my experience with it.
And that's basically similar. Uh, Renee, the next slide, please. Yes. Why will we consider non-party participation in mediation? Electra, why don't you take this one first?
Like I said, primarily the reason that I will do it is to help, facilitate the agreement and not leave, key elements out of the MSA, primarily, conservatorship and supervision. So if you have a child with relative or fictive kin, like I said, they need to be a part of that process. One, to make sure that they understand the scope of their responsibilities. As a conservator. Typically, what we try to do, if the child is with a relative or fictive kin, we have the Fostering Connections program. We try and get them stipends and subsidies through the Fostering Connections program. So a lot of our mediated settlement agreements we'll discuss both kind of what the conservatorship looks like while the participant is going through fostering connections, and then what the agreement looks like after the completion of the fostering connections program. Again, there's some debate about this because, we're effectively um, trying to mediate a cause of action that hasn't yet occurred because once the fostering connections is completed, then they file a modification and then give managing conservatorship to that individual. Um, so that argument can be raised, and it sometimes it is. But we do want to have those individuals present so that they understand, like I said, the scope of their responsibilities in completing fostering connections, the scope of their responsibilities as a conservator, and the scope of their responsibilities as it pertains to the supervision. Um, do you have anything that you want to add to that part?
Well, I was going to ask you, Electra, do you ever have situations where whether it's a family member or regardless of who it is exactly, they decide to forego the fostering connections and they would like to go ahead and proceed and have a final order entered?
Yes. Oftentimes, I mean, they understand, that they're waiving the PCA. The main thing that I get as far as why they don't want to participate is they just don't want CPS in their life that long. And
And I
and
was
they're
going to
willing
say
to
that's
forego any stipend in order to have that occur. So in that case, I will probably recommend and make sure, hey, have you talked to the kinship worker? Has this been explained to you? Do you understand, what you could be getting? Are you in a financial position to not get it? Because this money is guaranteed. However, if the parents are on child support, that is not necessarily guaranteed money. And if I understand that they understand everything and are waiving it anyway, then we'll proceed accordingly. And that might be when I would be like, hey, somebody get a kinship worker on the call or something like that.
okay. And that was my experience too. Typically, I'm always reminded of a famous quote from a mediation I did where the it was a fatigue problem. They were done with having CPS come around. It had been a case that had drug out for some time. And finally, the family member who had the children finally said, "Look, keep your money. Just give me the children," and that's always stuck with me. But that is a fatigue can be a factor in whether or not a family member is interested in going through the fostering connections. And I think an attorney needs to be aware of that. A mediator needs to be aware of that. That fatigue absolutely is a factor. Um, ICPC brings its own batch of problems. The kind of and this isn't the whole story, but I will say that ICPC has some requirements, and it is very much similar. If you're going to make a placement uh, with a family member under ICPC who is outside the state, then typically that has to be approved by the equivalent of CPS in the receiving state. And typically that's at least a 6 month process. So the child, uh, you know, Texas CPS has to inform the other state CPS, the receiving state CPS, that we'd like to enter a final order making the placement in your state permanent. So all of that has to be done before the mediation, if that is in fact going to be the proposed resolution at mediation. So it's very important if you represent the department to make sure all the ICPC, ducks are in a row. And if you're representing the party uh, whose family member is receiving the child, then that's something else that you need to at least work with them to make sure that that gets done as well. It's not You're not necessarily an advocate for something like that, but you are certainly something that your party may look favorably on. And so it's very important to make sure that the ICPC questions have been answered before the mediation so that there is not some sort of of speculation about how that's going to work out down the road, because then we run into the same situation that Electra was describing with fostering connections. We're talking about a final order that's going to happen at some point in the future. Uh, and a refiling or a motion to modify something like that. So the best possible solution is to make sure that the ICPC ducks are in order prior to the original mediation.
And we don't typically have the responding states departments on the call. Typically, the Texas Empower or the typically Empower will coordinate and speak with their counterpart in that state to kind of get more of an update to be able to give everybody. And we just know as a kind of an inside joke that if the ICPC is in the great states of Georgia or Louisiana, there's you just need to add some additional time.
I agree with you 100%. Build in some additional time because it could be a while before you get anything approaching an approval. ICWA, I think we've already sort of covered that. I think everybody knows that ICWA, I hope everybody knows, that the Indian Child Welfare Act has a priority placement list that includes uh, Native American families who may not necessarily be blood relatives of the child. And that's injected into the priority list of placements. So it's a tribal member who is not a relative of the child, and then just a Native American family who has no relation to even that tribe is on that list. So when you go through that list, make sure you're familiar with your hierarchy when you're talking about placements and potential placements at mediation. It never hurts to go back and check the U.S. code and make sure you're up to date on your placement hierarchy from ICWA. Uh, let's see. Electra, why don't you go ahead?
Yeah, we kind of talked about this a little briefly earlier, but non-parties as a source of information, a lot of that comes in mediation through either the caseworker or the guardian ad litem or CASA. I keep forgetting to include CASA in that. Um, in that, we never have the service provider themselves on the call, and we're careful regarding how medical information is presented. You know, there is a lot of this information is sensitive information, so you only as a mediator, you only disclose it to the extent that you have the authority to the people that absolutely need to have that information. So you treat, mental health assessments, medical information, and all of that, and therapy goals and assessments with the care that it deserves and respects. So, the extent in which I'll say things is typically like, oh, the department has a concern about the level of progress that you've made in therapy, or you know about being medicine compliant or something like that. But I try and make that information as general as I can to get the point across of the position without actually disclosing all of the specific information to any of the parties. Um, again,
Typically, that I was going to say that typically this issue comes up when really the child's therapy or progress is really the focal point of has become the focal point of the case. The services being rendered for the child, mom may have completed her services some time ago, but they're waiting for the child to complete to make some progress. The child, for instance, is in an RTC. They're looking to lower her level of care so that she could be returned home or returned to the location and that sort of thing. And so that's, the RTC. I'm thinking, you know what, we didn't list that on any of our slides, and we probably should, because a lot of times you may need information from the RTC about the child's progress, about the child's level of care, and things like that. And I agree 100% with what Electra's saying about this stuff is sensitive information. You have to be careful. In addition to the usual confidentiality that you have in a mediation from one room to the next, you also just can't go in there and say, well, we need to talk about, you know, the underlying medical issues here until and unless you have the authority to do that from whoever's authority you need. So I do think there is a place for the therapist at a mediation under certain limited circumstances. And the same is true for a parent. You may have some parents with some frankly, and I've seen that increasingly lately, with some very significant mental health challenges with a pre-existing diagnosis that requires substantial psychiatric, psychoactive medication and things like that. And the real question is what kind of progress is being made and that sort of thing. So you may need those assessments there. You may need to hear that information. If mom's saying, I'm ready to have my child back, and, her therapist is there to back her up, the parties may not necessarily have had access to that information. And under those circumstances, the therapist can be placed in the room and they can ask the questions and do that. I'm not fond of the idea of mediations becoming discovery sessions, but the reality of it is that many times they do become discovery sessions. And as the mediator, you want to try and limit the amount of time that you're spending on doing that. On the other hand, if it gets you to the end result of crafting an MSA that's good for the child and the parties can all agree to, you may need to have a certain amount of leeway in allowing some limited discovery style information from going back and forth. And I think that's what this whole slide is about.
And I will say I've gotten to a point now where it has to be very limited because I've chased down that rabbit hole many times where people use mediation as, fishing expeditions and discovery, basically like depositions and whatnot. And if it gets to a point where it's just clear that no one has talked to anyone about anything and there's no information that's been exchanged, I will recess and have them either go do discovery or go do an FGC, and then y'all can come back to me when everybody's got the information that they need.
Yeah, I 100% agree with you. Yeah, when anybody, and not just the department, but the parents' attorneys, when increasingly, and I don't know if this is just that I'm getting to be a grouchy old guy, but when you show up to mediation unprepared and you don't have answers to critical questions, both not only for your client, but from what the other side is doing, the best, rather than try and power through it because everybody's there, which is sometimes the gut reaction. I do agree. A recess is appropriate and say, look, you guys go clean up the loose ends. You guys get the information that you need to negotiate that. It's very similar to parties showing up to a family law mediation and they don't know the valuation of the house, stuff like that. It's like, you guys are not ready to mediate. Go get your information, go get authority that will cover all of the potential outcomes in this case. And the only way to do that is to have preparation. So we're going to talk about preparation more a little bit later, but this goes straight to that. Being prepared means you do have the answers. You are not there to conduct discovery, and you need to be honest with yourself about where the case is in terms of that before you agree to mediate. So I agree with you. We need to have more recesses and less trying to power through. Electra, why don't you?
Um, so who is going to participate? I think we've kind of covered that one.
I really think we have.
Yeah.
I think the critical issue on this side, and I'll skip down to the middle, is the part about whether or not if they're going to be in the final order or they need to be signatories to the final order. You know, somebody who is going to be made in the final order is going to be made the managing conservator of the child, who is not a party, absolutely should be participating in the mediation, and their signature is absolutely required. Okay, you've got to get them to sign off on it. I have had a situation where the plan was, oh, we're going to place the kids with grandma. And when grandma sat down and I said, Grandma, we're going to put the kids with you forever, she says, oh, no, you're not. Okay. And so it's a good thing that it was there in mediation. Imagine if grandma had not been in the mediation and all of a sudden there's this final order that makes her the managing conservator, which was a job she didn't want. So yes, if that person is going to be a conservator, that person in my mind must be. It's a mandatory person for the mediation.
And I will also say if the person that'll ultimately be a conservator, if there is a supervisor that is not that person, I will have them get that person on the call. Because what typically happens sometimes they'll be like, oh, my dad will supervise, and then, CPS is like, oh, her dad can't supervise because he's got 8 pending felonies and blah da 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 da. And then I go back in the other room, they're like, okay, well, my cousin will supervise. And I'll be like, get her on here. Like, I mean, I'm not, what's the point of putting it in an MSA? Because just because you think she's gonna supervise, and then what happens, we come back and like nobody consulted her, and she's like, I got stuff to do. And so anybody that's a supervisor or proposed to be a supervisor, I will, even if they don't, if they're not on the mediation, I'll have them put them on like speakerphone or something so I can have a talk with that person
Right.
to make sure that they're understanding what they are agreeing to. They don't necessarily need to be a signatory if they're just a supervisor, but they need to be a part of the overall conversation.
Okay. And just very briefly on the confidentiality, parties are bound by the confidentiality of a mediation. It is something of a gray area whether a non-party participant is bound. Typically, what I do, and we'll talk about that in just a minute. In fact, I think that's the next slide. Uh, in fact, Renee, if you want to go to the next slide, the idea of the confidentiality is something that I establish with the non-party before allowing them to continue in the mediation. I make it clear to them, look, we may talk about some things today during the mediation. You need to agree that you're going to keep that confidential. I've never had somebody say, no, I won't. And I don't recall ever having had that breached. So I think that's a great way if you're a mediator to make sure that you maintain the confidentiality of the entire process. In Dallas County, do the judges let you make the call, Electra,
About what?
about whether or not to include a non-party in a mediation?
Yes, the Dallas County judges give us the discretion to determine, who we feel like needs to be in the mediation in order to help best facilitate the mediation.
And that's my experience too in far west Texas and some of the other counties I've had an opportunity to mediate in, is the judge is going to let the mediator make the call. I think on some level, I think the judge just wants to know, do I have a mediated settlement agreement or not, and really doesn't care how the sausage gets made. On the other hand, and we're going to talk about that over the next couple of slides, is what do you do when a party has a very strong objection to somebody participating and they object to the mediation? Somebody could be referred to mediation. There could be a discussion where a third party may be participating, or they know a third party is going to be participating, and they could object to the court. That's going to be something the court decides. As a mediator, that's outside your boundaries. If the judge says, no, I'm going to allow the mediation to continue, then you take it from there. The balancing test, I think, is going to be the same for a mediator or a court in determining whether or not that party will appear. And that's, are they required by the agreement, like we were talking about, a potential placement or a potential conservator? Uh, the second thing on that list, is it more helpful than not? Well, you never know until the mediation gets started whether or not they're going to be more helpful than not. But typically, you can have some idea. Is it essential? Again, probably.
And for me, with non-parties, and again, I limit the amount of non-parties that participate in the mediation. So I basically beat people to it. Like, you don't have to object. I object unless this person
Okay.
is integral to this process. But another important thing is that for non-parties, especially, I let them know that, hey, you are here as a basis in order to give information. Like, the amount of information that you're going to receive during this mediation is either limited to non-existent. If you're here as a non-party, it's because I need information from you, not necessarily to give you the information of what's going on in the mediation.
Right,
Unless you're
absolutely. It especially an informational third party is absolutely not going to be receiving information unless I need something. I need to tell them something to elicit more information that they have. Typically, it's kind of a one-way street on an information type participant. Um, uh, all I think Electra and I do almost all of our mediations via Zoom. I'll be honest, I can't remember the last time I did an in-person CPS mediation, but it's been some time. I will say that I will tend to include somebody if the parties, requested, or the person comes forward, or there's some tie, somebody says this person needs to participate. My initial reaction is to include them and see if they can assist in coming to the agreement. My gut reaction is not exclusion. I suppose might be the same way. Is that how you feel about that, Electra?
I don't know. I think my gut is more exclusion until you can prove that you have some benefit to the mediation, because it's been maybe it's because it's just been my experience. Again, the more people you have, the more opinions that you have in trying to facilitate an agreement. And rarely have I included a non-party in a mediation that facilitated an agreement more than it disrupted an agreement.
Oh, can I ask, have you ever kicked somebody out once you let them in?
Yes.
Okay.
Unapologetically, yes.
Unapologetically, yes. Well,
Yes.
yeah.
You get a couple
If
warnings, but after that, that's a great thing
well,
about
right.
Zoom.
If you let them in and you kind of had them on a kind of a short leash, then yeah, I can understand that, and I have to. There comes a point where the disruptive factor has exceeded, their worth, and I've said, no, that's enough. And I said, thanks, and you'll get to find out how it ends later on, and I've excluded them too. But I will say it's pretty rare.
Mm.
Uh, Renee, next slide. There we go. The strong objection. We have talked about this. I'm going to skip down to the end because I think we've got a number of slides left, and I notice we're already into our last 15 minutes or so of the presentation. The tactical objection, and I have seen this a number of times, and I've given it as an example. Mom doesn't want her sister to be a conservator. Everybody else thinks it's a great idea. In fact, that's what she wants. And so she objects to the sister's participation. And this can be done at the court level, as we talked about, or at the level of telling the mediator, I want her excluded. Okay. And so then you as the mediator, if the court decides, the court decides. But if you as the mediator are left with making that decision, then you need to go back through that analysis. Have you ever seen anything along those lines, Electra?
Vaguely. It's not so much an objection, but I guess I would say somebody's like, "Oh, I don't want this person to be involved," and in which case that's fine. Just that person's not a part of the mediation, and I just get what I need from that individual, usually through the caseworker. So it's like, "Hey, is she available on Fridays from 6 to 8 to supervise?" They'll call, give me an answer, and we'll just move on.
All right. Let's see. Potential impediments to reaching a settlement agreement. This covers a lot of ground, and it's not just non-parties, but let's focus on non-parties. Electra, would you like to start this one?
Yeah, again, it's kind of the too many cooks in the kitchen kind of situation. There have been times in which let's say I do limit it to non-parties, but again, if somebody's at home on Zoom and their spouse is in the living room with them, I'll be talking to that individual saying, "Hey, this is your kid. You have to co-parent with this other person, so ultimately, it's got to be your decision." And then I'll talk to that individual, and they'll be like, "Okay, I get it." And then I'll go in another room and talk to somebody else. And when I come back to the other person, they have completely reversed positions. And that coupled with the fact that they're constantly looking off camera and there's a shadow in the background, I'm like, okay, well, I know what happened here. So yeah, like I said, sometimes um in my experience, it's the family members sometimes, or spouses, or loved ones or whatever, that prove to be more of the impediment.
Mhm. And that's my experience too. I have had situations, I'm sure you have too, where you've left the room feeling like you had that party's position on some issue, and you speak to the other parties, you talk, you work some things around, and then you go back to that room, and suddenly their position has changed. And they can do that without a third, a non-party intervening. Certainly that's happened enough times, but a lot of times when you've got the shadow on the wall, and you know that there was some discussion that occurred after you left, that can be particularly frustrating in a mediation where you do have, we typically in a child welfare mediation have at least four parties. And if sometimes you have five, six, seven, and it's taking you a long time to circulate through the parties, and then to find that sort of the rug has been pulled out of whatever it is you took around to the other parties, that can be exceedingly frustrating from a mediation point of view. And it's also difficult on the other parties. So the non-party participation is, one of those issues. What we talk about briefly on this slide is when you have a situation where there was a previously undisclosed position. And I know I hear you do the FGCs. I will tell you that the FGCs, in my experience, are not nearly as much of a sharing experience as you're describing, but that may be a regional thing. Where you have a position where a service provider has indicated to the ad litem or perhaps to the caseworker that there is a change in circumstances that the parties were not aware of during the mediation, then that is the kind of situation where they've just thrown a grenade basically into what everybody got to the mediation thinking. And so then it's up to you to decide, do we continue the mediation? Do we need to adjourn the mediation so everybody can verify this or take a different direction? Or perhaps re-prepare for the mediation. So that's something that the parties need to be aware of at that time.
Another issue I found with undisclosed or unknown information prior to the mediation is typically here we have the caseworker and a case supervisor on the mediation. We do not have the program director. So what will happen is the department will staff it with a certain set of facts and come to mediation with that, staffing in that position, and then some information will be disclosed during the mediation, and then you go back and it's like, well, I don't, basically the department's like, well, I don't have the authority because I need to talk to my program director. And I'm like, well, get him or her on the phone. Come on, let's go. Like, I mean, if I need the people that are able to make decisions to be part of the mediation.
Yeah, I agree. Unfortunately, and I don't want to like drop the hammer on the department on that one, but that's typically what I see. The problem is the program director's authorization has been exceeded. Perhaps the mediation took a different direction from what the department staffing thought it was going to do, or something else has come up that was unknown to the department. Giving them the benefit of the doubt. Uh, when that situation occurs, as soon as that situation occurs, the program director needs to become involved. I know they're busy people. I get it. We're all busy people. But the idea of the mediation is that the if the authority of the department's representative on the site has been exceeded, then we need to rope in, whatever we need to do, call to have that program director there. And that's on the department's attorney. The department's attorney is the one who bears the responsibility to the other parties and to the process of making sure that he has or she has the authority to proceed with the mediation. But it is not limited to the department because, as we said, sometimes the child, what the potential outcome is something different from what the child's ad litem team talked to the child about. And so they may need to rope in the child, bring the child in so the child understands. If the child thought he was going with grandma, but now the whole thing is shifted over and child's talking about going with his aunt in Maryland or something like that. Yeah, that's a big change. And that's the kind of thing where, yeah, you need to get the child on the phone, get him on the text. Goodness knows every child I know has a phone within 2 feet of him at all times, and get that child's authorization. And again, that's the duty of the attorney for the child to make sure that they have authority to agree to what's going on. Um, so that comes up. The placement's an easy one. Obviously, the placement needs to be there, but I think we've covered that. Other considerations. What are our other considerations, Electra? I think we've.
Um, yeah, I mean, I feel like a number of these kind of we've kind of addressed them in kind of like sidebar
Right.
comments and whatnot. Confidentiality. Again, I already explained that for me, if you're a non-party, it is a one-way street, as Mark called it. I treat them as individuals that are there to provide information to help me facilitate an agreement, unless, like I said, they're, um, you know, have a conservatorship or a supervision component, in which case I'll be a little bit more inclusive.
I agree. I think we've covered this one. Frankly, I think we've covered the next slide as well, but I think we've talked about that. The challenge of neutrality is something that is all mediators face, especially when we're dealing with a non-party. Almost all non-parties are not represented by counsel. And so under those circumstances, the mediators themselves need to be aware of not providing legal advice. That's not your job. That's not the hat that you're wearing that day if you're an attorney. That day you've got your mediator hat on. And so that's important. Sometimes the proponents, for instance, um, if you're the attorney for the party whose family member is going to be the placement, you also need to be aware of this. You don't represent them. You are not there to provide legal advice for a non-party. You are there to provide legal advice for your party. And so be aware of the neutrality issues. I definitely want to get to the last couple of slides. Electra, I know you know this slide better than anybody. Tell me.
Yeah, and that's also another wonderful benefit of having the mediations on Zoom. is that the instances of domestic violence, especially as it pertains in CPS cases, we're always mindful of it. When I was doing them in person, we would always be cognizant of it, have request additional law enforcement on the floor if necessary, and things of that nature. But we also, like I said, Zoom takes a big piece of that and makes people more comfortable because the abuser and the victim can be miles apart, and they feel more compelled to speak freely without any you know repercussions.
And I agree. I think that the Zoom mediations really gives the mediator an extra tool here to avoid those. But I will tell you, if in advising mediators out there, I think you should ask because we haven't really touched on it, but I think Electra and I both agree that we rarely get mediation statements at all, much less a mediation statement thorough enough to let us know, hey, there is an issue of domestic violence. We need to know that. Okay, we need to know that there has been domestic violence in the past between the parties. The mediators need to know that. So if you are a party, if you represent the victim, if you represent, frankly, whoever you represent, if you're one of the attorneys representing a party, you need to make sure that we know that there's a domestic violence situation or scenario involved. Uh, Non-party participation by a known abuser, I will tell you right now, somebody's going to have to talk me into that, and I think it's super unlikely that I'm going to go along with that. And if for whatever reason I was going to permit a non-party uh, person to be involved, it's going to be under some extraordinarily limited circumstances. The only way I can think of that this comes up is in a situation where mom has a new boyfriend. There's been instances of family violence with the new boyfriend that is separate and apart from the biological father who may be a party to the case. That's really the only way I can see that coming up. And the sad truth of it, the pragmatic answer is yeah, is he going to be there? May he be participating? Yes. But I'm also going to have to be able to tell the mother, and I'm sure their attorneys have told the mother, hey, look, if you're going to have domestic violence around in your child's life, you're not going to be a potential placement. You have the hard conversation. As the attorney for the mother, you should have had that conversation. But sometimes that's something that comes up in mediation. You need to be prepared for that.
And even though I don't get like anything settlement wise, like what you would get in like a private mediation, I do request and get the petition with the attached affidavit, and I will read the affidavit prior to the mediation to make sure I don't have, a situation like that where the new boyfriend or something is involved.
Yeah, part of the problem. The next slide is the other one that I wanted to get to. Mental health considerations. Our cases are, in my experience, have become increasingly centered on mental health considerations. Uh, Parties with pre-existing diagnosis, parties that are receiving psychoactive medication, parties that should be receiving psychoactive medication. Likewise, the same is true if you have a non-party who is participating for whatever reason, who lacks capacity. Uh, an example might be the child has Down syndrome, something like that. That's something that the child's ad litem team is going to take care of. Again, technically the child is a non-party, but in this situation, and then in the situation at the second point about the power imbalance between the parties, uh, be aware of these issues. I says be cognizant of them, be aware of them. I see nothing wrong with trying to hold the mediation together, but there may come a point in the mediation where you need to say stop. As the mediator, you may need to say stop. We need to address the issue of capacity, or we need to talk about those things and ask the parties to adjourn and come back when they have addressed those issues sufficiently to where you think everybody is participating to the best of their ability and certainly to the best of their understanding. I think that's incumbent on the mediators to make that call.
Absolutely. I've had situations where, like, when you're talking to somebody, sometimes it's a matter of, they understand it but just don't like your answer. And then there's times in which you can tell that they just don't understand it. And then I will pull that party's attorney into another breakout room and say like, hey, I have concerns that your client isn't really understanding whether it's a mental health issue, a cognitive issue, or belief that they're under the influence of something. I will say, hey, they don't look like they're getting it. Like, do you want to, I think we need to try this at another time, or I don't know if you need to assess whether or not that person needs a guardian ad litem themselves or what. And I'll have that conversation with their attorney, by ourselves so that and then they'll go back and have the appropriate conversation with their client.
Right. And when in tying that to the non-party, when it becomes clear to me, for instance, that a grandmother doesn't understand that the idea of her being the conservative is kind of an always and forever kind of thing, rather than, well, I'll wait until my daughter gets her act together kind of thing. That's the time, and it may be a capacity issue, it may be a lack of understanding issue. But until that is resolved, and until that's the case, until you as the mediator are clear in your mind that you feel like everybody understands what the end result of this mediation is going to be, then I think that's what you need to address it. Electra, I think we only got a couple of minutes left. Renee, were there any questions that we have time to address, or? Yeah, we do have this last slide. Yeah, go ahead, Renee.
I was about to say there is one question. If you want to go on to the last slide, then I'll provide that question to you.
Okay. The last slide is just really these are the people whose signatures are required. Again, in my mind, we absolutely have to have the signature of somebody who's named as a conservator, somebody that is addressed in the final order as a visitation supervisor. Another example of a non-party may be somebody who's going to provide housing. Uh, Mom agrees that she will live with grandma. Grandma's not a conservator, but she's going to agree under the terms of the mediated settlement to live in a specific place and be subject to some kind of geographic restriction. That person would need to, I think, sign off on providing that service. The tribe, and frankly, anybody who's mentioned in the terms of the MSA. Electra?
Oh, I mean, I agree. Anybody that basically has any type of responsibility, I feel like needs to be a signatory. I don't think it necessarily is necessary to have an executable document, but I just like for everybody um to be on the same page.
Renee, I think that's all we have.
We do have a question in the queue. So, agreements made by foster adopts placements to allow contact are not enforceable. So, how would you recommend that visits, information, or pictures, etc., be shared despite the fact that the agreements have no teeth?
Electra, what do you do on those?
Um, I'm not entirely sure how much I can do because Judge is correct that it doesn't have any teeth. So I mean to the extent that I can, I will make sure that any post MSA, I guess, agreements, or even the free agreement is in his MSA is properly filed with the court. We try to, in the MSA, make the parameters of of it, because the foster parents are not beholden to it, obviously, but we try and make it as specific and as convenient as we can to um, the foster parents because in my estimation and in my experience, they genuinely are. If they come to an agreement that they're going to do something, it's been my experience that they are willing to do it and will do so in earnest. What typically happens is something to the effect of, okay, well, I'm sending pictures, cards, and letters, but I'm not getting any. I'm just sending it out into the ether, and I'm not getting any response or something. So, we might make it so that the parent triggers, like a parent can get an email address and trigger the pictures, cards, and letters. Or if you send it and after a certain period of time or amount of time you're not getting any response or feedback, then you have no further obligation to do it. Not that they had any real obligation to do it anyway, but you know what I mean. And just kind of like make it as convenient as possible for them to do. But I don't know of any way legally to make it an enforceable situation because the parents aren't parties of the adoption, and then the foster parents aren't parties of the, the
Determination.
MSA that you're doing now. So I don't know how to make it anything other than the honor system.
The only thing that I've done is I've put the email address in the MSA that the foster parents will send the things to. But the the heavy part of that question is the explanation to the parent that, hey, they don't have to do this. This is not enforceable. That is a discussion that the parent's attorney needs to have. That is not the mediator's, not the mediator's problem. That's the difficult part of that conversation is up to the parent's attorney.
Well, thank you both, Mark and Electra. That is our time for today. In behalf of the Children's Commission, I would like to thank you both for that very informative presentation. We encourage all of our viewers to email any questions you may have to Mark and Electra via the email addresses on the slide for a response going forward. We also want to thank you, the viewers, for attending today's presentation. The State Bar has approved this course for 1 hour of MCLE credit and 0.25 hours of ethics. This course has also been approved by the Texas Board of Legal Specialization for 1 hour of certification and recertification credit for attorneys and paralegals in the specialty areas of child welfare and family law. Individuals who are watching this replay may contact CC Training at txcourts.gov for the MCLE self-report information. We hope that you enjoyed today's presentation. And as a reminder, you may register for all of our live webinars and access replays of this and our other MCLE webinar replays for free on our on-demand training and MCLE webpage.